record to reflect that Mr. Smerer is present in court with David Kelly. His attorney, Emily Donlin, is here from the prosecutor's office, and Scott Green is here from the Department of Corrections. This is the date and time the court has scheduled for sentencing in this matter. Mr. Green provided the court with a pre-sentence report and recommended sentence that I have reviewed. Have you seen that, Mr. Kelly?
Yes, Your Honor.
And have you had a chance to work with your client?
Yes, I have.
Seen as well, Ms. Donlin?
Yes, Your Honor.
I have one comment on corrections and deletions that I'm going to ask my usual question of the attorneys before I get into that, and you may have already noticed. But to either parties have any challenges to relevancy, accuracy, or sentencing guidelines?
Your Honor, I expect we're on the same page here. Our only note on behalf of the people, and we did confer with defense as well, as to the charge entered as count one. It does show the original charging language for count one, homicide, open murder, statutory short form. I believe at the time of plea, the court did accept a plea for homicide, first degree, premeditated murder. So we would just ask that the PSI be amended to reflect that as the final charge. But
I think that that's important simply because of the nature of an open murder charge. It's usually first degree or second degree, but in theory, depending upon what a jury would decide or the court decide, if the court was sitting as a trier of fact, it could be a lot of other things. So I think it's important that that be noted, and that's kind of why at the time of the plea hearing, I made a special record as to what I believe the facts as provided by Mr. Smerer were showing. So I think that that is a correction that should also be made. Mr. Kelly?
We have no objection.
The other thing that I noticed, I don't believe that Mr. Smerer is entitled to 291 days credit on the principal convictions offenses because they are all subject to a felony firearm mandatory minimum 2-year sentence, which is to be served consecutive to the predicate felony. So he gets credit on each of the felony firearm charges of 291 days. And we'll get to the details of that when we get to sentencing. But and those 5 felony firearm charges will run concurrently with each other, but they will be consecutive to the predicate felony to which they're attached. So he gets credit on the felony firearms, but not on the other. And to the extent that the report reflects that he does, that is inaccurate.
Your Honor is correct.
Your Honor, for clarity's sake, count one should read, because the ROA indicates that it was homicide, open murder, statutory short form. The information that we received from the court reflected the same thing, because I brought that up myself. And I was directed to put it in there the way that it is. So I want to make sure that we have the correct thing.
Well, I don't know exactly what Ms. Donlin suggested, but the court found, based upon the testimony of Mr. Smerer at his guilty plea, that the facts as he articulated them to the court established without any doubt that his conduct was premeditated and that it was his intention to kill all 3 of the children that were shot. He was successful in one of those situations and not successful in the other 2. So the homicide is a premeditated first-degree homicide. The others are what they are because they are attempts or other forms of assaultive behavior with a firearm. So, Ms. Donlin, could you state again what you directed the Probation Department, Department of Corrections to say as far as the charge in count one?
yes, Your Honor, it's the people's position that it should read as count one, homicide, murder, first degree, premeditated. And that would be PAC code 750.316-A for the reasons stated in the record.
All right. Any other challenges to relevancy, accuracy, or sentencing guidelines scoring?
No, Your Honor.
No, Your Honor.
All right, thank you. Mr. Smerer, this is your opportunity to address the court regarding sentencing if you would like to do so. If there's anything that you would like to say to me, this is your chance. No, you don't want to say anything else, Mr. Kelly?
Yes, Your Honor.
Buckle up, everyone. because what starts as an ordinary sentencing hearing quickly reveals the weight of an unimaginable crime. As the judge reviews the record, one legal correction changes everything. The court confirms this wasn't just a homicide, but a premeditated murder. Then comes a moment everyone notices. The defendant is given one final chance to speak. But the courtroom is met with silence. That silence says more than words ever could. And now the defense must attempt the impossible.
Sentencing hearing I have participated in. Nothing that can be said today diminishes the horror of what occurred on September 11, 2025. One child lost his life. 2 children suffered catastrophic injuries, one of whom may live the remainder of her life confined to a wheelchair. The family has been forever shattered. There simply are no words that can adequately express the magnitude of that loss. Mr. Smerer understands that. More importantly, he has accepted responsibility for it. Unlike many defendants facing the certainty of spending the remainder of their lives in prison, Mr. Smerer did not force Brandy, Bentley, Kinsley, Aiden, law enforcement officers, medical personnel, or this community through a lengthy trial. He entered a plea of guilty as charged to every count. He has never attempted to blame anyone else for what occurred. In the written statement contained in the pre-sentence investigation report, he plainly acknowledged that he shot 3 of his children, killed Caleb, permanently injured Kinsley, and caused immeasurable harm to all of them. That plea cannot undo the damage. It cannot restore Caleb's life or erase the trauma suffered by Bentley and Kinsley. But it is a meaningful act of accountability. One of the most troubling aspects of this case is that this tragedy was not born of a lifetime of violent criminal behavior. Mr. Smerer came before this court with virtually no felony record, 2 misdemeanor convictions. He'd maintained steady employment for nearly 20 years, supported his family, and had been the primary financial provider through his marriage. The pre-sentence investigation report itself recognizes that prior to these offenses, his criminal history was almost non-existent. That history does not excuse what happened. It does, however, demonstrate that this offense occurred during an extraordinarily deterioration of Mr. Smerer's mental health and personal circumstances. Shortly before this tragedy, Mr. Smerer had the opportunity to receive treatment through the St. Clair County Mental Health Court. Tragically, that opportunity never materialized. On August 26, 2025, 2.5 weeks before this tragedy took place, Mr. Smerer was denied participation in the mental health court, a treatment court for misdemeanor offenses, of which his was, for the following reasons. The defendant is not diagnosed with a serious mental illness, serious emotional disturbance, or a developmental disability, does not meet mental health severity criteria. Now, I'm not here to point the finger at anyone. The seriousness of Mr. Smerer's mental health issues were not spotted at that time. On the morning of September 11th, 2025, Mr. Smerer awoke with a sentencing hearing scheduled for later that morning. He was facing a recommendation of 365 days in jail for a misdemeanor offense that took place years earlier. He had already lost the job he had held for nearly 2 decades. He had lost the family housing that had accompanied that employment. His depression and anxiety worsened. According to the victim impact information contained in the PSI, he had stopped taking his prescribed medication approximately 5 days before this incident. None of those circumstances justify his actions, but they help explain how an individual with virtually no history of serious violence arrived at this unimaginable point. Obviously, with Mr. Smerer's apparent mental health issues, I referred him for an evaluation relative to criminal responsibility at the Michigan Forensic Center. Both Dr. Mishira Oliver from the Forensic Center and Dr. Michael Abramsky concluded that Mr. Smerer did not satisfy Michigan's legal standard for an insanity defense. The legal standard for insanity, however, is extraordinarily narrow. A finding that someone was legally sane at the time of their crime does not mean that the person was mentally healthy. Those are very different questions. Indeed, the record demonstrates that Mr. Smerer had long-standing diagnosis of depression and anxiety requiring medication, and even the victim impact statement from Mrs. Smerer reflects her belief that what he experienced is what she described as a psychotic break, that he snapped under the overwhelming pressures he was experiencing. She further expressed her belief that life imprisonment may not be the appropriate punishment because, in her words, he was not in his right mind. Again, that is not a legal excuse. The law requires life imprisonment, and Mr. Smerer knew that when he pleaded guilty. Mr. Smerer will carry the consequences of the morning of September 11, 2025 for the remainder of his life, regardless of the sentence imposed. Every day, he will know he caused the death of his son. Every day, he will know that Bentley and Aiden and Brandy must live with the consequences of what occurred. Every day, he will know that Kinsley may never walk again because of his actions. I say may because I believe in the power of medical advancements. There's always hope. There is no prison sentence that can exceed that emotional burden. The mandatory sentence on count 1 leaves this court with little discretion concerning the homicide conviction. We recognize that reality. Your Honor, I think the only issue that I think I would like to at least briefly bring to the court's attention here is that there is a recommendation of continuing a no contact order with Mrs. Smerer and the children in this case. It's my understanding and has been brought to my attention by both Mrs. Smerer and the prosecutor that I believe the victims may be addressing that later in the sentencing hearing. I'm asking the court to keep an open mind on that issue regarding no contact based on the victim input. Thank you.
All right. Thank you, Mr. Kelly. Ms. Donald.
Your Honor, a number of
All right. Everyone, this is where the defense tries to explain the unexplainable without denying the devastating facts. The attorney points to years of steady work, a nearly spotless record, and a mental health crisis that allegedly spiraled out of control. But even as those arguments unfold, one truth hangs over the courtroom. Nothing can undo what happened. And just when the defense finishes, the people most affected finally step forward to speak.
the named victims of this offense are present, and do you wish to submit to the court a victim impact statement if so allowed?
Absolutely.
Thank you, Your Honor. Your Honor, approaching the podium at this time are Aiden Smerer and minor victim B.S. Bentley Smerer here. I know the name has been stated on the record, so we'll go without initials at this time.
Who's going to be first?
Me, Judge.
Say your name, please.
Aiden Smerer.
Go ahead.
I honestly didn't really know how to start this, but I just kind of want to start off by saying that my brother killed was one of the most amazing people in this world, and his life was taken in it like that. He just woke up every other morning, got ready for school, watched his TikTok, doing whatever. He was on the couch with his backpack on, waiting for him to take him to school. And he was able to go up to him, point a gun at him, and pull the trigger. And that was his favorite son. That's what don't make sense to me, bro. That was his favorite son. That was his whole world right there. And he was able just to do it. And then he was able to go into the next room and do it to his second favorite, his only daughter. Just like that. Just like that, he was able to do it. It would never make sense to me. And then he was able to do it again to my other brother. And thankfully, he was able to run and get help. Because cops would have not got there as quick if it wasn't for my brother right here. And I'm so glad that I still am able to have two of my siblings. Because I could have lost 3 siblings that day. I lost an entire family that day, but I'm so glad I'm still able to talk to 2 of my siblings. And I personally, you deserve life plus 1. I wish you could live 2 lives tonight. that's I will never understand. You could explain it to me a million times, I'll never understand once. Mental health stuff, like, men's mental health is not talked about enough. I suffer from it. I have depression and anxiety. I got help. I took time away from my personal life and got help. I listened to people. I got the help I needed. Look where I am today. I'm doing a lot better than I was at that time. I'm not saying that everyone is the same way, but that's not the way to go about it. There'll never be an okay excuse for mental health, no matter what. Everyone in this room has experienced mental health. No one has done the things that you have done in this room. Ever. So.
Now the atmosphere changes completely. A surviving family member walks the podium, and every eye in the courtroom turns in the same direction. What follows isn't legal testimony. It's raw grief. The victim relives a mourning that shattered an entire family, rejecting every possible excuse and demanding accountability. With every sentence, the silence inside the courtroom grows heavier, and incredibly, the most emotional. Testimony is still yet to come.
Say your name, please.
Bentley Smell. That morning, my brother was killed. The first thing he said to me was a good morning. I didn't know a good one had started with shooting me in the face. You just look everything coming to you. You can cry all you want, it won't change a shit thing. You crippled my sister, you killed my brother. Your own children. That you loved your entire life just to kill. Just think about that. And you deserve everything coming to you.
Thank you.
Your Honor, Kingsley Smerer is also present in the courtroom, and we do have a microphone attached to her at this time.
Thank you, Your Honor.
Oh, thank you.
My name is Kingsley Smerer. I would like to say that he was a good dad, and I woke up that morning not knowing what was going to happen. I woke up thinking that it was going to be a regular day, and we were going to go to school. But it turned out to be a horrific day, and he was a good dad. He did all he could for the family, and then he got accused of something, and then lost everything. He went to community health center, he asked for help, and he was hearing voices, and no one gave it to him. And so as soon as something happened, nothing had been done. And he asked for help, and no one gave it to him. It makes no sense, and no one will ever know why he did it. He wasn't only my dad, he was my best friend, but he decided that he was going to hurt his children for some reason, and no one will understand why. He was a good dad, he was a good person, but he had a mental break, and no one knows why. And he woke up that morning, woke his kids up, and chose violence. He killed one of his kids on the couch. He went right behind him and shot him in the head. The kid, had his backpack on, he was ready to go to school. He was always ready early in the morning, but my dad decided that he was going to go and shoot 3 of his children because he had a mental break. We all got ready. He woke us, he came in my room, woke me and Belly up, said good morning, and then we went, and Bentley was laying on the bed with his son, and we were just waking up, and he decided to shoot Caleb first. We were in our room, and he shot us for no reason. And no one understand why he did it, and he would never understand. Caleb was already ready for school. He was on his couch with his backpack and everything, and he got shot. Me and Belly weren't even ready for school. We were trying to get ready, and then we got shot. That's all I have to say.
Thank you.
Just when it seems the emotions couldn't run any deeper, another survivor begins to speak. The memories are vivid, The pain is unmistakable, and the anger is impossible to ignore. Family members describe a father they once trusted before everything changed in a matter of seconds. Their words leave the courtroom frozen, raising one haunting question that no one can truly answer. Why did this happen? Next, the prosecution delivers its final response.
Your Honor, we have no further victim statements at this time.
Okay.
Your Honor, when we have a case of this sort, a tragedy of this magnitude, I think that the only response and the natural response is to look for answers, and I think that's clear in the statements of the victims here that this was a senseless, tragic event, and the pain it has caused is, I would say, immeasurable. When any sort of offense of this nature occurs, it affects not only the immediate victims, but the community as a whole, and the overall sense of safety of everybody around them. But here, the most tragic part of this entire situation, of the actions that were taken that day, is that the people who have been hurt the most are the people who had the greatest trust placed in Mr. Smerer, who had the greatest love for him, who were in the most vulnerable position because they put him in that position of trust, his own family members and his own minor children. I think it's clear in their statements that the pain he has caused is just beyond what we can put into words, and it's something that is going to continue to be dealt with for a very long time to come, for the rest of everyone here's lives. I think if we search for answers here, there's no answers to be found, because this type of act is just something that can't be explained with the kind of logic that we're looking for. But what is clear here is that what happened was the result of Mr. Smeer's actions, not just one action, not the action in a single moment, but again and again and again, choices made by no one other than Mr. Smerer. And the impact of those choices just can't be overstated. And because there were choices that were made by him clearly, one after the other, as noted in his factual basis to his plea, that he was considering this and contemplating this, and not just that morning, but in the time preceding that, the weeks preceding that, and that on that date, there were multiple times when he could have reconsidered, when other choices could have been made. But tragically, this was the choice that was made over and over as to each of the victims here. And as they're all grappling with what that means, I think the law is clear on what it has to mean for us here in this courtroom, and I think that law is in place for a reason. And I would ask that the court follow what is in the recommendation and follow what is, I think, the only viable option to address the tragedy of this magnitude in these circumstances.
All right, thank you, Ms. Dowman. Anything further to read from the Department of Corrections?
No, sir, there's nothing there.
Mr. Smerer, I kind of agree with Mr. Green that there's not a whole lot that can be said or needs to be said at this particular point. A lot has already been said. There have been a lot of emotions that have been incurred and experienced by a number of people, not all the same, obviously, and those are what they are. Hopefully, in time, some of those things get better. The one thing that I can agree with and that I can say is perhaps a good thing, and there's very little that can be said that is good, and that is you entered a guilty plea as charged to all counts, and that had the effect of avoiding a very lengthy, very emotional, very difficult trial that probably would have resulted in the exact same outcome that your guilty plea did. And to the extent that that was avoided, that is a good thing for those victims. The one thing that still haunts me to some extent, Mr. Smerer, is listening to you describe in your plea hearing how you decided that morning to hunt down your own children for the purposes of killing each and every one of them. You also told me that it was your intention to then kill yourself. But you decided that morning to hunt down your own children who were doing their usual morning routine, and they were totally defenseless. They had no idea what was coming, and they had no ability to protect themselves. And it is a tragedy beyond description. Fortunately, the law in the state of Michigan addresses what is appropriate for purposes of punishment when it comes to the homicide offense. Nothing less than life in prison without the possibility of parole is appropriate under these circumstances. The other sentences somewhat pale in comparison to that sentence because it is a life sentence. It is intended to be, and that's exactly what it is going to be. As to the other offenses or the other conviction offenses, those are going to be served concurrently with the life sentence, which is required by law. We've already talked a little bit about the felony firearm convictions and how those are going to work. We talked about that at the time of the plea hearing. But to try to simplify things, I want to state that all of the felony that are...
With the victim's statements complete, the prosecution brings the courtroom back to the law. They argue this wasn't a single impulsive act, but a series of deliberate choices that forever changed countless lives. Then the judge reflects on the defendant's own admissions, recalling details that leave the room in complete silence. It's now clear that this hearing has reached the moment everyone has been waiting for. The final sentence is only moments away.
There are a total of 5 felony firearm convictions. Each felony firearm conviction requires that the court sentence you to a mandatory minimum of 2 years in prison. And that sentence is to be served consecutively to any predicate felony to which it is attached. In this case, there are 5 felony firearm convictions and 5 predicate felonies. And each of the felony firearm convictions will be served concurrently with each other, but they will be served consecutive to all of the other predicate felonies, even though it may seem somewhat redundant to order that there is a felony firearm conviction that has to be served prior to and consecutive to a life in prison without parole conviction. That's what the law requires. So as to count 1, which is the open murder, which I have found that it is the equivalent of premeditated, first-degree premeditated murder. It is going to be the sentence of the court that you be committed to the Michigan Department of Corrections for the remainder of your life without the chance of parole, with credit for 0 days served. That is the predicate felony for the first felony firearm, which is required that you serve 2 years with the Michigan Department of Corrections with credit for 291 days served. As to counts 3, 5, 7, and 9, that is assault with intent to commit murder, 2 counts, and 2 counts of child abuse first degree, it is the sentence of the court that you serve a minimum of 20 years with the Michigan Department of Corrections to a maximum of 40 years with 0 credit for time served. The felony firearm convictions that are attached to those predicate felonies, the sentence there is once again a mandatory 2-year prison sentence with credit for 0 days served. And these felony firearm convictions and sentences must be served and completed before the predicate felony sentence begins. So they are in fact consecutive to those offenses. So I hope that I have said that correctly and simply, and not going through and reading everything that needs to be said. I think everybody understands how it is going to work. Do you have any questions, Mr. Smerer?
No, Your Honor.
Mr. Kelly, any questions?
No, Your Honor.
Ms. Donlin?
No, Your Honor.
Mr. Green? So if everybody is in agreement that the court has ordered a valid sentence, then that is in fact the sentence of the court. A judgment of sentence will be prepared and signed by me that's consistent with what I have said here this afternoon. Mr. Smerer, it is my obligation to inform you that you have the right to file an application for leave to appeal your sentence conviction if you wish. And there's a form that explains your appellate rights, and contained within that form is information that allows you to request the assistance of an attorney in connection with an appeal if you are so inclined.
This is the final chapter of a heartbreaking case. The judge carefully explains each sentence before officially ordering life without the possibility of parole, along with additional consecutive prison terms required by law. The courtroom remains quiet as the reality of the punishment settles in. With the hearing coming to an end, one family begins a difficult journey of healing, while another faces consequences that will last a lifetime. If you found this courtroom breakdown insightful, be sure to like this video, subscribe to the channel, and turn on notifications so you don't miss future cases. Thanks for watching, and we'll see you in the next video.